have Dr. Risham Garg with us to deliberate on the topic penal provisions under IBC laws. I would like to read his brief profile before all the participants. He is Associate Professor of Law and Director of Central for Transnational Commercial Law at National Law University, Delhi. He holds a doctorate of law in the area of international commercial laws. He is a member of INSOL India and INSOL International Academic Group. He is also involved with the IBBI in consultations, organizing roundtables. He also assisted in IBBI in continuing professional education for insolvency professionals. He's also benefited from the WBIFC and IBBI training, the trainer for insolvency professionals. It's been a truly privilege for ICSI IIP that Dr. Risham Garg is with us for today's session. Over to you, sir.
Thank you, ICSI IPA, and thank you, CS Surbhi Jain, for the wonderful introduction and inviting me for this session. And I thank you all of the experts and insolvency practitioners who have joined early morning on Saturday to listen and deliberate on this very topical issue. So the IBC, as you all know, IBC was drafted in 2016, and there are a few provisions which involve offenses and criminal provisions. Now, why do we need offenses or criminal provisions? Apparently, there is a fear psychosis. In legal terms, we call sanction. So the question is, why should people observe law? And usually, we understand that mostly people live in a civilized society and they want to observe with certain rules and regulations and the decorum. However, some people are like outliers, or if the legal enforcement is not strict or is not there, then people will not observe the law. So some people, observe law if they see that others are also observing, so we should also do. But then there must be some sanction involved. Then again, wrongs can be classified civil wrongs, criminal wrongs, and again, there are consequences, which you call as sanction. So usually for civil wrongs, the consequences of the sanction is compensation, monetary compensation. And for criminal wrongs, which are classified as offenses, the sanction or the the consequence is in the form of penalty or fine or imprisonment. And as you all are aware, some of you are lawyers, and whenever you are filing cases, you all observe that whenever there is a criminal provision, for example, this was one of the main reasons why the dishonor of checks was made into a criminal offense. It is another matter that there is still lots to be deserved regarding the enforcement and the resolution of cases. However, there are civil wrongs and there ought to be civil consequences in the form of monetary compensation. But because of certain aspects, some of what we have observed is the court processes in the civil courts. The process is quite delayed, takes a lot of time. There are a lot of interventions, interjections, and adjournments, and so on. So people want, and again, the consequence of monetary compensation may not be that strong a deterrent. Hence, a stronger deterrent or a stronger reason for people to fear will be the criminal wrongs and providing for criminal consequences, not just fine, penalty, but also imprisonment. Now, in these last 4 or 5 years, you must have observed, you must have seen the various provisions under the Insolvency and Bankruptcy Code relating to the offenses and penalties. I will just go through them as well. But starting, we have this discussion paper by the Ministry of Corporate Affairs issued in the January 2023, which I'm sure you must have gone through and must have had several occasions to be involved in deliberations on this topic. But let me just take some more time to discuss. So as you read this, it starts with empowering the adjudicatory authority to impose penalties for violations of the code. So it provides you certain, situation. What is the present situation? So section 235A of the code provides the punishments to be imposed for contravention of the provisions of the code or rules or regulations framed thereunder, for which no penalty or punishment is specifically provided under the code. The punishment under this provision is administered by the special court established under Chapter 28 of the Companies Act through criminal proceedings. So, the criminal offenses, wherever there is a criminal trial, because the NCLT is a court of summary procedure, it cannot conduct a trial, and more so, the criminal court system is different, and the criminal courts are bound by the Code of Criminal Procedure, and they try these criminal wrongs, and those criminal courts are only competent to award imprisonment. So hence, for corporate crimes in the Companies Act of 2013, where the Companies Act also provides for criminal offenses, corporate crimes, and imprisonment, because they cannot be tried by the NCLT, special courts needs to be constituted. So these special courts usually, some of you might have gone already. So they are usually existing district courts, existing criminal courts across the country, who are also designated as the special court under the Companies Act. Then, but through these, let's say, 10 years or so of the Companies Act and the Companies Act of 2013, although the modern Companies Act goes back to 1956. So we have around half a century of experience with the Companies Act. So these offenses are thought, is a hurdle, and there has been widespread consultation to decriminalize the offenses, the corporate or the business offenses. Similarly, in the last 5 years of IBC, or now it's already 6 years and moving into the 7th year, 7 years of IBC, there is again a strong move to decriminalize some of these offenses. So this discussion paper also provides, although everybody is anxious when these amendments will see the light of the day, whether they will be introduced into the budget session. They were not introduced. People are waiting whether anything will be introduced in the monsoon session. Regardless of that, but there is a dedicated policy push, and the policy push is that there is a need to decriminalize offenses in the business law statutes wherever feasible. And hence they have suggested that this section 235A must be converted into a civil penalty. And there are various reasons. Some of these are that you need to go to the existing criminal court, and they will run by the code of the criminal procedure. And then it becomes difficult, it becomes complicated. So if the NCLT is the dedicated adjudicatory authority for all the company matters and the insolvency matters, then the NCLT must have the entire jurisdiction. So it should be able to decide on all of these things. So as far as possible, that does not mean that the element of sanction or the serious wrongs be taken away from the corporate wrongs. That should stay, because this is serious matter. It's a company is like a trustee, is a fiduciary of the shareholders, of the workmen, of the lot of people. There are a lot of stakeholders. So because of that, there is a public trust involved, and hence some serious corporate offenses and the consequences must be there. So we need to balance. So the government, the policy is clear. There is need to balance between the need to decriminalize the non-serious business law wrongs and but still retaining the serious corporate criminal offenses. So some of these examples are provided. For examples, if the promoter of a CD does not cooperate with the RP or liquidator, then such conduct may be proceeded against under this provision for the levy of penalties on such promoter. So, well, this again, whether this amounts to a wrong which may be resolved through or which may be addressed through penalties itself, or it is a serious wrong which should be triable, there should be a punishment. So there are certain issues which are considered upon observing the law in practice, and also listening from the stakeholders, the important backbone of the insolvency code, the insolvency professionals. So I then again, if you look at some other discussion in this paper, further observe that several proceedings are also maliciously instituted before the adjudicatory authority to delay the conduct of processes. Proceedings are also initiated with no reasonable prospect of success or based on insufficient evidence submitted without any purpose to determine the actual issue. These proceedings take up a substantial time of the adjudicatory authority, which can be utilized for other matters, resulting in the draining of resources for the concerned parties and causing delay in the conduct of insolvency resolution processes under the code. Therefore, it is being considered that the code should have a mechanism to discourage the initiation of such proceedings. Section 65 of the code provides a penalty against fraudulent or malicious initiation of the admission proceedings. However, no penalty is imposed on other proceedings filed before the AA. Hence, it is being considered that the AA should also be empowered to impose a penalty where it believes that such a person has filed frivolous or vexatious applications. So you may again think that, why are we discussing this? Theoretical or this policy aspect is very crucial, because this gives you the purpose. You are important stakeholders, important pillars of the entire insolvency and bankruptcy ecosystem. And at every stage, your views are sought, and the government, the insolvency board, the IPAs, they are trying to make the system as robust and as efficient as possible. So another important reason, we have a ready-made commentary in front of us. So this is the commentary. What is the applicability, utility, and let's say the future policy for Section 65? So 65 provides already a penalty. However, no penalty is imposed on other proceedings filed before the AA. Now, in other countries, in countries like US, there is heavy cost. Heavy cost if in civil litigation, there are heavy consequences. I should not say only costs, but there are heavy civil consequences. So as far as litigation is concerned, sometimes or most of the times it also happens that an option is provided to the litigant before the trial, at the commencement of the trial. That is usually called as a pre-trial procedure, where they are asked whether you want to continue or not. And they are told that if you want to continue, what will be the consequences? And maybe one of the consequences can be that entire costs may also be imposed upon the party who is unsuccessful, or if the suit is not maintainable. So this is a general background. I did not want to take much of a time, but I do believe this is a very serious issue, and is concerns an ever let's say the development, the continuous development of this code. So I believe there is a Mr. Jain wants to ask a question. You are welcome, Mr. Jain, Jitendra Jain.
Sir, one thing you are saying these penalties, whatever have been mentioned under IBC, they are of penal nature and thus adjudicating authority cannot what you call impose that. So what is the basis for that? If you can clarify further.
Yeah, yeah. Yes, thank you. So, actually, I had started with a background explanation, and I, you know, this is a discussion paper. This is the discussion paper which was released by the Ministry of Corporate Affairs in 2000, in the January of this year. It is a proposed, it is proposed amendment. So it has not yet been converted into the code, or it has not yet been notified. So these are just discussions. But why I am discussing this is because it provides a good commentary, a good background of what is the reason for these, let's say, offenses and penalties. So I will be discussing the existing law. Okay, so I have not yet started discussing the existing law in the IBC. I have some of these presentations which I have already shared, and which might have been shared with you, or which will be shared. So I will discuss in detail what are the existing provisions which are in force. However, this was a general idea to provide to you, to explain to you the push of the government to decriminalize certain non-serious business wrongs, and wherein if there is a provision for punishment is given, if it is felt that some of those wrongs are non-serious nature, rather a alternative can be that adjudicatory authority might be provided the right to give award penalty in those circumstances. This is a conceptual introductory discussion. Till now I have not yet started discussing upon the existing code and existing law. Just clarifying that. Yes, Mr. Jain. Mr. Jitendra Jain, you want still to
Yeah.
ask
So
something?
you mean to say this discussion paper without any basis has just assumed these are the penalties of criminal nature and adjudicating authority cannot impose that?
See, this discussion paper is in the public domain since January 2023, and before this discussion paper there was a good brainstorming colloquium in November last year. So I mean, these are some discussions which provide you an insight into the law that is taking shape.
Because we have seen in many cases, including if I remember Hirakun case of under section 65, ANCLET has imposed penalty. So what is the basis these discussion paper taking the what you call discussion to a backward, then to what you call seize the power which already exists with the adjudicating authorities?
No, I think
And
you have no, I think you have misunderstood. Section 65 is existing; it is already there, but the proposal is, if you read, no penalty is imposed on other proceedings filed before the adjudicatory authority. So there is no discussion on Section 65. Rather, this provides that similar to Section 65, these type of penalties may also be extended to matters on other proceedings, right? So 65 is only penalty on fraudulent or malicious initiation of admission proceedings. So you have to understand the nature of this proceeding. So it is admission proceeding, but there are other proceedings also. There are, interlocutory orders, there are other interim miscellaneous applications and so on. So there are several other type of proceedings which are not classified as admission proceedings, but still they take up precious time of the adjudicatory authority. So this discussion paper is suggesting that could this section 65 penalty be extended to cases which are not classified as admission proceedings.
But sir, as I understand, please, there is no bar on adjudicating authority to impose penalty even under section 235A. There is no specific bar. Rather, it is the adjudicating authority who firstly adjudicates, and then it should go to IBBI only for a particular prosecution. So how it is possible that adjudicating authority cannot impose penalty and then it goes to IBBI?
So I think what will I'll do is I will rather not. I was just my purpose was to explain to you the existing commentary rather than not uh, ensuring a discussion on this topic, because we should rather be debating upon the law which is proposed, so the draft law was not declared. This was declared, and this was already in the public domain, and people have given already their suggestions 2 3 maybe 4 months back. So some of your points we will discuss when I discuss some of those provisions. So I'm sorry, the purpose is not to have a discussion on this discussion paper, but the purpose of this discussion paper was to provide a commentary, a background of what is the purpose of the criminal provisions and what is the future way ahead. So I'll rather move on to these penal provisions now. So what are these penal provisions under the code? So as you can see here, starting from section 68. So when we read chapter 7 of the Insolvency and Bankruptcy Code, it starts with these offenses and penalties. And section 68 and which says that where any officer of the corporator has, within the 12 months immediately preceding the insolvency commencement date, willfully concealed any property or part of such property of the corporate debtor, or concealed any debt due to or from the CD of the value of 10,000 rupees or more. So the qualifying is that the property must be at least rupees 10,000 worth. Then B, fraudulently removed any part of the property of the corporate debtor of the value of 10,000 rupees. So A says willfully concealed, then B says fraudulently removed, then C says willfully concealed, destroyed, mutilated, or falsified any book or paper affecting or relating to the property of the corporate debtor or its affairs. Then D, willfully made any false entry in any book or paper affecting or relating to the property of the corporate debtor or its affair. So first, what are these various circumstances in section 68? A is willful concealment of property. So the threshold is rupees 10,000, which is quite low threshold. Then B is fraudulently removed any part of the property. Then third, C is willfully concealed, destroyed, mutilated, or falsified any book or paper affecting or relating to the property. Then D is willfully made any false entry in any book or paper affecting or relating to the property of the corporate debtor. Then E is fraudulently parted with, altered, or made any omission in any document affecting or relating to the property of the CD. Then F, willfully created any security interest or transferred or disposed of any property of the corporate debtor which has been detained, which has been obtained on credit and has not been paid for unless such creation, transfer, or disposal was in the ordinary course of the business of the debtor, or willfully concealed the knowledge of the doing by others of any of the acts mentioned in clauses or the which are mentioned above, which are C, D, or E. So these are the 7 circumstances which are provided. And then at any time after the insolvency commencement date, committed any of the acts mentioned in these clauses, or has the knowledge of doing by others. So these seven type of activities against the property or books or security interest, or has the knowledge. So 68(2) says even if any person has the knowledge, officer of the corporate debtor has the knowledge, then again third says after the ICD taken in pawn or pledge or otherwise received the property knowing it to be so secured, transferred or disposed, then such officer shall be punishable with imprisonment for a term which shall not be less than 3 years. So the offense uh, is imprisonment minimum of 3 years and maximum of 5 years, and the fine can be minimum 1 lakh, maximum 1 crore, and the court can also have a discretion that both of these uh, punishment can be awarded. So the imprisonment can also be awarded and the fine can also be awarded. The only proviso, that the only exception is that if this person proves that he had no intent to defraud or to conceal the state of affairs of the corporate debtor. Now, starting in this section 68 itself, now this proviso provides a very valuable principle, and which provides the exception. Exception is he had no intent to defraud or conceal the state of affairs of the CD. So in criminal wrongs, and again, why this has to be tried by the criminal court. Criminal court, the criminal jurisprudence is settled. To establish a criminal wrong, the mens rea, the mental intent is essential. So it's not just that the act was done, but it has also to be proved that it was done with the intent of doing a criminal act. So the mens rea has to be proved, and the court of the criminal court, the judge looks into this trial and finds out whether this has been satisfied. Yes, Mr. Jain.
Sir, on the practical side, if we see this section refers to officer of the corporate debtor. And if we further see the definition of officer refers to the definition of officer in default as per Companies Act. So technically, it is only the board of directors or CEO. So when we usually ask information from them, they provide whatever they have or they don't provide. But the problem is the destroying the documents and concealment, because usually these are the lower level employees who are being asked to destroy and not to provide that. So that situation, how do we can cover in this section? Whether the law of delegated legislation or something like that can be applied in this section?
Yeah, so this the recent amendments in the Companies Act identify the KMP. So it's not just one or two officials. The KMP are mentioned, key managerial personnel are mentioned, and I believe in some of those circumstances, the as you are mentioning, lower level employee who is actually interested may also fall into the category of that key managerial personnel. It does not need to be the hierarchy, top in the hierarchy only. Apart from that, there is a settled criminal jurisprudence that complaint. So there have been these cases which started from this Bazi.com case, then Airtel case. The complaint has to be made against both the company and the individual. So the company is also liable, but the individual, because the individual did that act, and individual did that act on behalf of the company, but individual had that mental intent, mens rea, and that has to be satisfied. So when the complaint is filed or when the case is filed against the company management will usually, they will conduct some inquiry that who is the actual person who did that. and whether any individual overstepped their responsibilities or not. So the trial will be against the KMP and the company, and I believe that should cover most of the circumstances that you are addressing. Okay, so the principle in section 68, these uh, 7 circumstances are mentioned, and a consistent rule, the jurisprudence of criminal trials, criminal liability, which is mens rea. So that exception is provided in the proviso in section 68. The next is section 69. Now, section 69 provides for punishment for transaction defrauding the creditors. Now, if an officer of the corporate debtor or the CD himself has made or caused to be made any gift or transfer of or charge on, or has caused or connived in the execution of a decree or order against the property of the corporate debtor, or B, has concealed or removed any part of the property of the corporate debtor within 2 months before the date of any unsatisfied judgment, decree or order for payment of money obtained against the corporate debtor. Such officer of the corporate debtor or the CD, as the case may be, shall be punishable with imprisonment for a term which shall not be less than 1 year, but which may extend to 5 years, as you can see here, or with fine which shall not be less than 1 lakh rupees, but may extend to 1 crore rupees, or both. So again, in the even when we read the Code of Criminal Procedure, and even in the IPC, the code, the Indian Penal Code, so these are punishments are consistent, and you might have seen similar offenses in the Companies Act as well. So these section 69 deals with the situations which are transactions that defrauding the creditors. So in these circumstances, the punishment is there, one imprisonment 1 year to 5 years, and fine 1 lakh rupees to 1 crore rupees, or both. Now the exception is if the acts were committed more than 5 years before. So the look back period for section 69 is 5 years. So beyond 5 years, if the wrong was committed, then it will not be considered. Or if he proves that at the time of commission of those acts, he had no intent to defraud. So the mens rea, the intent defense, is a inherent ingredient of the criminal law jurisprudence. So to establish the criminal culpability, mens rea has to be established, and the look back period, or the limitation period, as we may say, it is 5 years in this circumstance. Then moving on to section 70. 70 is the punishment for misconduct in course of the CIRP. Now 70 reads, on or after the ICD, when the officer of the CD A does not disclose to the RP all the details of the property of the CD and details of transactions thereof, or any such other information as the resolution professional might require, or B, so first is, does not disclose to the RP all details of property and all the transactions. Then B is, does not deliver to the RP all or part of the property of the CD. So first A is disclose information details, B is deliver the property or part of the property, then C is deliver to the RP all books and papers in his control or custody, then D fails to inform the RP the information in his knowledge that a debt has been falsely proved by any person during the CIRP. Then E is prevents the production of any book or paper affecting or relating to the property or affairs of the CD, or F accounts for any part of the property of the CD by fictitious loss or expense, or if he has so attempted at any meeting of the creditors of the CD within 12 months immediately preceding the ICD. So F is accounts for any part of the property by some fictitious loss. So he says that, you know, within 12 months of the ICD, he says he has, you know, delayed, and now he's saying that this property is lost, or due to, but there are some fictitious expenses or losses. So then the punishment is 3 years, not less than 3 years to 5 years, and fine again 1 lakh rupees to 1 crore rupees. So the punishment is more or less consistent in some of these offenses, 3 years to 5 years, and fine 1 lakh to 1 crore. And the exception is, the exemption given to the CD or official of the CD is the if he had no intent to do so in relation to the state of affairs of the CD. So again, the mens rea is an exception. Now, however, interesting part of section 70 is section 70 subsection 2 provides, if an insolvency professional deliberately contravenes the provisions of this part, he shall be punishable with imprisonment for a term which may extend to 6 months, or with fine which shall not be less than 1 lakh rupees, but may extend to 5 lakh rupees, or with both. So, section 70 subsection 2 also provides the penalty or consequences for the insolvency professional, and which is imprisonment to 6 months, imprisonment for a term which may extend to 6 months, or with a fine which shall not be less than 1 lakh and extend to 5 lakh rupees, or both. So imprisonment till 6 months and fine 1 to 5 lakhs is possible for the IP as well under section 70 subsection 2. This is punishment for misconduct in course of the CIRP. Yes, Mr. Sunil Kumar.
I have a question, like in this section 70, it is there, it is mentioned that if officer is not deliver any property or does not provide any document or do any fraud like this. Similarly, in section 19.2 also, it is mentioned that the corporate debtor officials of the corporate debtors shall provide necessary assistance to the insolvency resolution professional or interim resolution professional. So under this situation, we as a insolvency professional have we can file an application before the adjudicating authority for seeking the necessary assistance from the officials of the corporate person or corporate debtor. So under these circumstances, like how these two sections are interlinked with each other, or do we need to file separate application under this section 70, or section 19.2 will suffice, or how this will work out, sir? Please advise.
Yeah, so section 19, you know, usually will be in the, let's say, first week or the first month. Ideally, it should be in the first week itself. When the CIRP is admitted, application is admitted, the first things will be that the IRP will go to the company to get the moratorium enforced and take over the control of the assets, and also seek the cooperation. So this is, you know, that this is a court order, and you might have also observed that first you go there and then I mean, now though I don't think there is a big issue, but previously when the code was freshly enacted, most people did not know what is the code, what is the NCLT, and hence upon deliberation, this provision was added into section 19, that in case there is no cooperation from the CD or its officials, then the IRP may make a application to the adjudicatory authority, and the adjudicatory authority may direct the CD or its officials. So, there are several stories. Uh, if you take this NCLT order to the CD will say, "What is this? I don't know." People went to the police station for it to enforce the court's orders. Sometimes, in some places, police also does not know what is NCLT. So those were those issues, but I don't think that is relevant now. But as far as the difference is that Section 19 is that when you have immediately upon the admission of insolvency and imposing of moratorium, you have gone to the company to take over the control and get the books of accounts and so on. So this is 19 is to seek cooperation. However, 70 is punishment for misconduct. So if there is misconduct, so first is they are not cooperating because they are saying that we don't know, or there is a lack of cooperation. Lack of cooperation is not the same as misconduct. So 20 is for misconduct.
Okay, thank you.
Then 71 is punishment for falsification of books of the CD on and after the ICD, where any person destroys, mutilates, alters, or falsifies any books, papers, or securities, or makes or is in the knowledge of making of any false or fraudulent entry in any register, books of account, or document belonging to the CD with intent to defraud or deceive any person, he shall be punishable with imprisonment to 5 years or with fine which shall not be less than 1 lakh rupees, but may extend to 1 crore rupees or both. So then for falsification of books, again, section 71 is very clear, and false or fraudulent entry, then again, these are again the similar type of consequences: punishment, imprisonment 3 years to 5 years, and fine 1 lakh to 1 crore rupees or both. Then section 72 is punishment for willful and material omissions from statements relating to the affairs of the CD. And where an officer of the CD makes any material and willful omission in any statement relating to the affairs of the CD, he shall be punishable with imprisonment for a term, again 3 years to 5 years, and fine 1 lakh to 1 crore rupees. 72 is for willful and material omission from statement relating to the affairs of the CD. So these are these sections from 72. Next is 73. 73 is punishment for the false representation to the creditors. And 73 states, where any officer of the CD, A, on or after the ICD, makes a false representation or commits any fraud for the purpose of obtaining the consent of the creditors of the CD or any of them to an agreement with reference to the affairs of the CD during the CIRP or the liquidation process. So this 73A is where any officer of the CD makes a false representation or commits any fraud for the purpose of obtaining the consent of the creditors. Then B is prior to the ICD has made any false representations. Then again, this punishment is the same, 3 years to 5 years, and penalty 1 lakh to 1 crore rupees. So these are all called detailed, and these are detailed consequences, very severe consequences upon the CD or its officers.
Excuse me,
Then
this slide is not changing. I don't think it's any
slide,
difficulty.
I'm reading 73, 74 actually. 74, can you see section 74?
All right.
Right.
There's no slides.
Slide is there?
See, yes, section 68 is showing.
Okay. So I'll
No,
just...
section 74 is also there. The slide is totally visible. No issues. 74, 77, 73, 74, then 77.
Yeah, so in this slide, I'm just reading the short form, a gist, and detailed I'm reading from the Bare Act. So 74, this is 73, and then 74. I'll now read 74. 74 is punishment for false representation to the creditors. and it reads where any of his, sorry, 73 I have read, now 74 is punishment for contravention of moratorium or the resolution plan. So 74 is, as you can see here, where the CD or any of its officer violates the provisions of section 14 moratorium, any such officer who knowingly or willfully committed shall be punishable with imprisonment, again 3 years to 5 years, and fine 1 lakh to, but here fine is 1 lakh to 3 lakh rupees or both. So contravention of moratorium is punishment 3 years to 5 years, and fine is 1 lakh to 3 lakh rupees. And then if the creditor violates, so 74, one is CD violates, so punishment for CD will be imprisonment 3 years to 5 years, fine 1 lakh to 3 lakh rupees or both. Then 74 subsection 2 states, if the creditor violates the provision of moratorium, then this punishment will be 1 year to 5 years, shall not be less than 1 year, but may extend to 5 years, or fine 1 lakh to 1 crore rupees. So here there is some difference. Punishment imprisonment is 1 year to 5 years for the creditor COC, and fine is 1 lakh rupees to 1 crore rupees or both. Then 74(3) says if CD or any person violates the resolution plan, willfully contravenes any of the terms of the resolution plan, or abets the contravention, such CD officer, creditor, or person shall be punishable with imprisonment of not less than 1 year, but may extend to 5 years, or with fine which shall not be less than 1 lakh rupees, may extend to 1 crore rupees. So for contraventions of 74 subsection 3 is very clear. For contravention of the resolution plan, anybody, CD or creditor or any other person, the imprisonment can be 1 year to 5 years, and fine can be 1 lakh to 1 crore rupees or both. So 74 subsection 3 is crucial for everybody, CD and also the creditors or any other person on whom the approved resolution plan is binding under section 31. Then section 70, so I may not have mentioned 74(3) here, but I've just read it actually. So 77, it says 77, but I'll just still read through all of these provisions. 75 is punishment for false information furnished in the application. Where any person furnishes information in the application made under section 7, which is false in material particulars, knowing it to be false, or omits any material fact, knowing it to be material, such person shall be punishable with fine, which shall not be less than 1 lakh rupees, but may extend to 1 crore rupees. So punishment for false information in application under section 7, punishable with fine. So this is, again, as we have read, the fine is 1 lakh rupees to 1 crore rupees. So this is in false information under section 7 application. Then section 76 is punishment for non-disclosure of dispute or payment of debt by the operational creditor. So these provisions are very crucial, the starting point, and all of these, the parties, be it the FC or OC or RP, IRP, CD, officials, all should be aware about these provisions which are mentioned in this chapter. So this is chapter 7 on offenses and penalties. So 76 is punishment for non-disclosure of dispute or payment of debt by the OC. Now 76 says in A, an OC has willfully or knowingly concealed in an application under section 9 the fact that the CD had notified him of a dispute in respect of the unpaid operational debt, the full and final payment of the unpaid operational debt, or any person who knowingly and willfully authorized or permitted such concealment under clause A. Such OC or the person shall be punishable with imprisonment 1 year to 5 years, fine 1 lakh to 1 crore rupees. So 75, 76 similar provision. 75 applies to the FC section 7 applications, and 76 applies to the OC section 9 applications. So again, this is, taking and wasting valuable time. So these are again good strict consequences for false filing in the courts, in the NCLT. Then 77 is punishment for providing false information in application made by the CD. Now, what happens in section 10 applications? So again, this is 3 years to 5 years, and fine is 1 lakh to 1 crore rupees. So 75 is for false information in section 7. Then these punishable with fine. Fine is 1 lakh to 1 crore rupees in case of FC. In case of OC, section 76 provides imprisonment 1 year to 5 years and fine 1 lakh to 1 crore or both. And then for section 10 application, 77 provides for, again, imprisonment 3 years to 5 years and fine 1 lakh to 1 crore or both. So in this sense, 76 and 77 consequences are similar, quite similar. Then 77 provides for, 77A is there, punishment for offenses related to the pre-packs. And in this case, if the CD provides any information in application under section 54C, which is false in material particulars, knowing it to be false. So again, there is an intent, mens rea intent, knowing it to be false, or omits any material fact, knowing it to be material. So the mental intent, mens rea, is there. Or B, a CD provides information in the list of claims B is CD provides information in the list of claims or the prelim information memorandum submitted under section 1 of section 54G, which is false in material particulars, knowing it to be false or omit such material facts. And C, knowingly and willfully authorized or permitted the furnishing of such information. Such CD or person shall be punishable with imprisonment 3 years to 5 years, fine 1 lakh to 1 crore rupees or both. So this is the same, nearly the same punishment consequences for the OC under 76, CD in 77, and for the CD in applying for pre-packs in 77A. Now, 77.2 also provides that if the director or partner of the CD deliberately contravenes the provisions of Chapter 3A, then such person shall be punishable with imprisonment not less than 3 years, but which may extend to 5 years, and fine 1 lakh to 1 crore or both. Then there is an explanation as well. For the purpose of sections 75, 76, 77, and 77A, an application shall be deemed to be false in material particulars in case the facts mentioned or omitted in the application, if true, or not omitted from the application as the case may be, would have been sufficient to determine the existence of a default under this code. So explanation is provided as to what is deemed to be a false in material particulars. So these are the first set of offenses which are provided in part 2, chapter 7. Then any okay, so let me move on to the next phase, section 185. Now, if there are any questions, please let me know, or observations. Now, section 185 provides for punishment for contravention of provisions. Now, part 3, part 3, chapter 7 provides for offenses and penalties, section 184 and 185. And 184 is punishment for false information by creditor in the CIRP, in the IRP. I mean, it can be the liquidation as well. So if a debtor or creditor provides information which is false in any material particulars to the resolution professional, he shall be punishable with imprisonment for a term which may extend to 1 year, or with fine which may extend to 5 lakh rupees, or with both. So 184 provides that if debtor or creditor provides information which is false in material particulars to the RP, he shall be punishable with imprisonment 1 year, extends to 1 year. So maximum is 1 year, or with fine which may extend to 5 lakh rupees, or with both. So maximum imprisonment is 1 year and maximum 5 lakh rupees, or both. So this is applicable to both debtor and creditor providing false information, material particulars to the RP. So this is a very crucial bit of information, section 184 for the RPs, that either debtor or creditor provides false information and amounting to material particulars. Then 184.2 says, if the creditor promises to vote in favor of the repayment plan dishonestly by accepting any money, property, or security from the debtor, he shall be punishable with imprisonment for a term which may extend to 2 years, or with fine which may extend to the 3 times the amount equivalent. So anyway, so I mean 184, 185 is there, but I'm not sure if anyone is going to has used it. But still, you should know wherever it may be applicable. So this is the law. So we have read what is during the CIRP, and now what is during the insolvency, the bankruptcy processes. So for the bankruptcy, if there's an individual bankruptcy or the personal guarantors is going on, then what is the role of section 184 and 185? So in case of personal insolvency, 184.1 provides that imprisonment up to 1 year, or fine up to 5 lakh rupees, or both, to either debtor or creditor providing false information to the RP. So some of you might be involved in the individual insolvency with personal guarantors. So in case anyone has resorted to 184, that would be good insight for us. So I just wanted to know how many of you, so how many of you, have been RPs since the code, maybe 5 years or more than 5 years? Or any one of you involved in the personal guarantors cases? So these are 185, then 186, punishment for false information, concealment by the bankrupt. And then again, 187 provides for punishment for certain actions. And these are offenses and there is punishment and fine or both. So in case of the individual insolvency, sections 184 to 187 provide for these offenses. Then about section 220, let us move on to the IPAs. So section 220, subsection 3. So in case of the disciplinary proceedings, so when we read this chapter on inspection and investigation, which are complaints against the insolvency professional agency or its member or the IU. So 217 says any person aggrieved by the functioning of an insolvency professional agency or IP or IU may file complaints to the board within such time in such manner as may be specified. And then there will be investigation. And section 219, there will be a show cause notice. And then 220 mentions the appointment of a disciplinary committee. So in the disciplinary committee, section 220 subsection 2, on the examination of the report of the investigating authority, if the disciplinary committee is satisfied that sufficient cause exists, it may impose penalty as specified in subsection 3, which is 3 times the amount of loss caused or likely to have been caused to the persons concerned on account of such contravention, or 3 times the amount of unlawful gain made on account of such contravention, whichever is higher. So the penalty for offense under section 220 subsection 3 is this. So this is the disciplinary committee, and if it is satisfied that sufficient cause exists, then it may suspend or cancel the registration of the IP or IPA or even IU. And 220 subsection 3 provide that the following penalty can also be imposed. So actions against the IPs under section 220 subsection 2, suspension or cancelling the registration, and 3 provides 3 times the amount of loss caused. This is the fine. The proviso states where such loss or unlawful gain is not quantifiable, the total amount of the penalty imposed shall not exceed more than 1 crore rupees. So in case the amount is not quantifiable, then the total amount of penalty shall not exceed more than 1 crore rupees. Notwithstanding anything, so the non-obstante clause says the board may direct any person who has made unlawful gain or reverted loss by indulging in any activity in contravention of this code to disgorge an amount equivalent to such unlawful gain or aversion of loss. So 4 also states that the board may direct any person who has made unlawful gain to disgorge an amount equivalent to such unlawful gain. Then the 5 says the board may also provide restitution to the person who suffered the loss. And so what is restitution? So interestingly, 220 subsection 5 provides an interesting remedy. Any person who has suffered this loss. So basically, if the CD has suffered a loss, then any person who has been responsible will be asked to disgorge, and the person who has suffered will be provided restitution. So 220 subsection 3 provides for imposing of the fine, and 4 also provides for the disgorging of these unlawful gains, and subsection 5 provides that the person who has suffered will be entitled to the restitution. So any questions still here?
Excuse me.
Yeah.
Yeah, I'm Dr. Ajay Tukral.
Yes,
So,
please.
as far as 219 and 220 is concerned,
Ji.
so there is one very interesting aspect of punishment.
Hmm.
As we know that to act as IP, there are two requirements. One is we need to have license, and another is we need to have AFA. Now, as soon as a show cause notice is issued, the AFA is suspended. So that virtually enables an IP to continue the profession of IP. So the punishment starts running right there and then. The moment show cause notice is issued, the punishment starts to run. And so many of the case laws that we have studied, those are passed by IBBI in various disciplinary proceedings. None of the orders deal with what happens with the punishment already undergone by these IPs. Somewhere the time taken is maybe 3 years, 2 years, 1 year, and after that again the license is suspended. So this, I believe, is a double punishment kind of thing. There is a regulation 23A in model bylaws also that says that moment this show cause notice is issued, the AFA is suspended. And then 7A of IB regulation is also there. So I think we need some deliberation on this aspect.
I would like to, I would not say that I agree with you, but yes, I share, I understand your sentiments. I understand
No,
your
it's not the question
sentiments.
of sentiment actually. It's not sentiment. I am IB, I never handled any assignment so far. I practice only as an advocate, but I had the opportunity to represent a couple of IBs before the board, before Honorable Punjab and Haryana High Court as well. But it's very strange that the punishment starts to run the moment show cause notice is issued. It's very strange actually. It should not be so. The law should not be so. I think this needs to be rectified. I mean, the moment show cause notice is issued, you cannot carry on the profession. And once the punishment starts running, after the order is passed, another punishment is imposed without dealing what happens to the punishment already undergone. I mean, this is a something which affects each and every IP.
So thank you for your, observations, Mr. Tukral. I will, I will confess that I have not uh, gone through such situations or circumstances. But in case any of these following, I mean, fellow IPs would like to comment, you are most welcome. Yes, Mr. Jitendra Jain would like to say something.
Sir, not only what Mr. Thakral said, but also see the quantum of penalty which has been mentioned in 220. It is firstly on notional basis under Red Way section 70 subsection 2. What could have been the loss? And on top of that, it goes up to 3 times. So you see as against the principle or the law of damages that it should be on actual basis. Even on presumptive basis or notional basis, such a provision has been kept for the particular reason only the author can tell us. But in any case, such a particular what you harsh provision of no use when what you cannot even establish, then what is the logic behind it?
Well, I think I cannot disagree with you, but I will, admit that this is something which I do not have much exposure to or experience in. So I will refrain from providing my comments on this. But however, I do understand your logic and the grievance that you have raised. So in case anyone else has any observations or comments,
Sir,
you are
one
most,
more query.
yeah.
See, if you see the section 69 to 73 or so, especially 69, 70 and 70, yeah, 69 and 70, there is a repetition
Okay.
of certain what you call offenses.
Mm-hmm.
And as we know that one can be punished for an offense only once. So for any offense to be classified has to fall in one of them, or because otherwise it will not make any sense if that offense is falling under two categories mentioned in section 69 and 70.
No, see, no, I'll say that I think that the legislature has taken
Kind
care.
of categories with mention, they are what you call kind of overlap.
Well, I may not agree with you on this. I would maybe, it may appear similar, but when the code is drafted, the drafting team takes care that the overlap is to a minimum, because these are very crucial. Criminal has very severe consequences, so they have to be very cautious in drafting the criminal provisions. So they
Correct,
may look,
because
but my view will be they may look similar, but I do not think there will be overlap. Firstly, and secondly, uh, as our lawyer friend Mr. Thugral will also, I'm sure, agree that to establish an offense, the ingredients needs to be established, and there is no bar that against one person multiple offenses can be proved and tried and punishment can be given. The only thing is that for one offense, two type of punishment cannot be given. However, one person can commit possibly any type of wrongs or offenses, and in case the ingredients are satisfied, then the proceedings may continue against those type of offenses. So I will say that the legislator and the drafters have been careful in, they may be similar, but there will be difference, and I would like to assure you that great care is taken in drafting these provisions so that there is minimal overlap, and there must be some distinction, some distinctiveness is always there. In case any other of our IP friends might have observation on ingredients or offenses under section 69 or 70.
Actually, as far as IP is concerned, or maybe anybody, the mens rea is the most important condition. There's a criminal intent in the criminal law. So unless criminal intent is proved, I don't think it would be easy to get anybody convicted. And secondly, I see that section 233 is almost an ornamental that provides protection to the IPs for actions taken in good faith. I mean, this is seldom touched by any court or even the IBBI while dealing with so many disciplinary cases.
Right. Well, well, it is there. I'm not sure to what extent it's ornamental, but yes, thank you for your observations, Mr. Thukral. Yes, as we mentioned, and we must emphasize upon the IPs that to prove any offense, the ingredient of mens rea must be proved, and it is not easy. The criminal trial, has to take place in the special court, and it is under the CRPC, and it's not easy. It is very serious matter. Okay, so 74 I have covered. Then yes, this is also I have covered. All right. So the next topic is section 236. Okay. So I wanted to take up trial of offenses by the special court as well. Uh, is it okay if we can take a 5 minutes break or 5 to 10 minutes break?
Yeah, that will be fine, actually. You have been talking for a long time.
Yeah, so allow me 10 minutes break. We will resume at 11.
Yeah, sure, sir.
Sure, sir. Sure, sir.
Okay, so okay, so friends, let's join again. And section 236 is trial of offenses by the special court. And before I start on section 236, wanted to just provide some information upon the special courts. So I hope I'm audible and you are comfortably able to see the presentation.
Yes, yes, completely audible.
Thank you. So what are the special courts? So a special court is a court with a limited jurisdiction that deals with a particular field of law rather than a particular territorial jurisdiction. So as we have seen that NCLT are established and usually they have a subject matter jurisdiction which is on Companies Act matters and insolvency, and also the territorial jurisdiction that is within the particular state. Then the legislature has introduced special courts on many occasions through various laws, usually with the intention to enable quick and efficient disposal of cases. The IBC envisages the concept of special courts from the Companies Act. Okay, thank you. So the intention behind setting up these courts is to let magistrate courts try minor violations, and that graver offenses should be dealt with special courts. These courts are notified under section 435 of the Companies Act. Under section 435, it is the central government which must establish or designate a special court for the purpose of speedy trial of offenses. Accordingly, the MCA has issued several notifications. Existing courts in the state of Maharashtra, JK, Goa, Gujarat, MP, West Bengal, then so all these places have been designated as special courts. And as per the notification, these courts have been designated for the purpose of trial of offenses punishable under the Companies Act with imprisonment of 2 years or more. So as we know that NCLT are courts of summary trial, summary jurisdiction, they cannot conduct a detailed trial. And more so, these are mostly civil in nature. So corporate commercial is considered to be civil, and they do not even take a trial. They are not a trial court. They do not go into the matters of fact and evidence and procedure. So it is considered that commercial matters are easily established. So please, I'll just request anyone whose mic is on to please mute your mic. Maybe there may be some background noise which is filtering in. Yeah, so as far as these courts are concerned, the NCLT does not enjoy any trial jurisdiction. They do not take evidence. They do not conduct trial. But as we have seen for criminal matters, trial is required. They need to take evidence, and they are not summary courts, so the detailed, there has to be establishment of guilt. And again, imprisonment, if when they are dealing with imprisonment of 2 years of more, then it requires, committing them to trial, taking evidence, and going through that entire criminal procedure. So like sometimes existing courts, existing criminal courts or magistrates, they are designated as the trial courts. In Delhi also you will find that under the IBC, some courts, existing district courts have been designated, like there is one in Dwarka District Court, there is a designated special court to try the company offenses and also the IBC offenses. Now, special, Mr. Jitendra Jain, do you have a question at this time?
One thing, sir, the designated code, I think there is a what you call judgment of Bombay High Court that only ACMM code can be designated in note session, and that in Maharashtra actually there is no designated code. Is that correct? If you, it is in knowledge.
No, I am not aware about that, because that would be, people in Maharashtra would be better knowing that situation.
Okay, because I have seen that judgment. Maybe I will share with you. Okay.
Sure.
Okay. Thank you.
But, if we see section 435 2A, so there is a special provision that only the court of session judge or ADJ can be designated as special court, not that of metropolitan magistrate or the first class magistrate.
Thank you, Mr. Thudal.
Yeah.
So the special courts under IBC are vested with the criminal jurisdiction rising out of offences as laid out in Chapter 7, while the procedural aspects of the code maintain that the adjudicating authority is empowered to arrive at a finding or observation, and that certain action comes within the purview of Chapter 7 of Part 2. Once such finding or observation is made, the power to initiate a trial shifts to a special court. This shall be deemed to be a court of session, and the person conducting the prosecution shall be deemed to be a public prosecutor. And then section 236 of the code thus lays down that offences shall be tried by a special court established under Chapter 28 of the Companies Act. However, the corporate offenders in the above mentioned cases undergo a trial only when the prescribed authorities approach the court of law with a complaint. So the Companies Act also identifies that because it's a criminal matter, it should start with filing of a complaint. Hence, the special courts can take cognizance of the offences only when a complaint is made by the central government, the IBBI, or an authorized person, as the case may be. So authorized person in such circumstances can also be, I believe, the RP. The RP can also initiate a complaint in such matters. The MCA had earlier proposed for setting up 8 courts to deal with the insolvency offences. Now, section 236 provides that starts from the non-obstante clause that notwithstanding anything in the CRPC, offences under this code shall be tried by the special court, and no court shall take cognizance of any offence punishable under this act, save on a complaint made by the board or the central government or any person authorized by the central government in this behalf. And the provisions of the CRPC shall apply to the proceedings before a special court, and for the purposes of the such provisions, the special court shall be deemed to be court of session, and the person conducting a prosecution before a special court shall be deemed to be a public prosecutor. So this explains that it emphatically explains that this special court can only be a court of session, not below it. Then again, a notwithstanding clause. In case of complaint, the presence of person authorized by the central government or the board before the court trying the offences shall not be necessary unless the court requires his personal attendance at the trial. Then section 237 provides that the High Court may exercise as far as possible all the powers conferred by chapters 29 and 30 of the CRPC on a High Court as if a special court within the local limits of jurisdiction of the High Court were a court of session trying cases within the local limits of the jurisdiction of the High Court. So this is when we move on to these sections. Section 236 is trial of offences by the special court, and then section 237 is appeal and revision. So where there is a trial of offence by the special court, then its appeal will go to the High Court, that particular High Court. So this is with respect to the court. So usually company matters and insolvency matters are filed in the NCLT and appeals go to the NCLAT. But 236 and 237 provide that criminal offences will be tried in the special court and the appeals from the special court will go to the High Court. Yes, Mr. Jain.
So, sir, RP can't make a complaint under this provision and he has to knock the door of IBBI only.
Yes, it appears so that only the central government and the IBBI is authorized. So I'm sure the procedure is in place that the RP can make that relevant, provide that relevant information to the board, and the board will examine. And then, because the board will take the legal opinion whether the complaint needs to be filed and proceedings initiated in the special court.
Sir, is there any circular of that procedure or is it a generic thing? Because if you can highlight.
I'm not sure about the procedure, but I think this must be some practice. I believe the IPAs might have provided some information, but I'll just look into it and provide you that information as well.
Okay. Secondly, sir, why IBBI? Why not MCA? Because if you see the scheme of act, section 70 subsection 2 is for offences relating to IPs, and IPs under jurisdiction of IBBI. And rest of the things should be with the MCA. So whether MCA has authorized IBBI for everything or it is still overlapping.
Right. So you need to know that these criminal matters, the affected person, so the person who is aggrieved himself can file the complaint. So usually now these are representative suits. So there is no, let's say the affected party is the company and the company is being managed by the RP. So under that fiction, can RP file the complaint? So RP may not be authorized because RP has not been aggrieved. So hence it is the government, the ministry, the central government or the board who may consider on the behalf of the company CD or any of the stakeholders who is aggrieved that they may file such a complaint. Because in case, any of your activities, as Mr. Tukral will also be able to explain, that if you are doing your any professional work, then usually there is no personal animosity or personal action. But in case there is a personal action directed against you, then certainly you will have a right to file any criminal complaint. But if it is in the nature of a job and the individual is not directly affected, so in these circumstances the complaint cannot be filed on behalf of someone else. So this right can only be exercised by the central government or the board.
Sir, as per the very scheme of the Act, for example, the Companies Act, for any offence under the Companies Act, only the Registrar of Companies or any other officer who is authorized in this behalf can file a complaint against a company or the directors of the company, whoever is the accused. an individual cannot file a complaint for any offense under the Companies Act. For example, 447 is there which deals with fraud. So an individual cannot file a complaint under 447. But under IPC, yes, an individual can file if there is a grievance of fraud. Then under IPC it can be filed. But as far as Companies Act is concerned, only the central government or a person authorized by the central government can file a complaint. And similarly, as far as special courts within the scope of IBC, and it is very specifically provided in 236 subsection 2 that no court shall take cognizance. That means a court will not entertain any complaint if any individual comes to the court. Court just cannot entertain a complaint. So complaint can be filed only by the board or by the central government or any other officer authorized by the central government in this behalf. So that is the very scheme of the act.
Thank you, Mr. Tukral.
No, so, sir, my query is with different. See the scheme of act, there are two designated authorities. One is MCA, second is IBBI. IBBI is vested with the power to regulate the IPs. One thing. So is and certain what you call prosecution and punishment, where section 70 subsection 2 regulate 220, that is within the domain of IBBI. Then why IBBI is doing for everything and not MCA? Or MCA has authorized IBBI to do everything for under the act?
So I believe, so I don't, and I'm not sure that I was able to understand. Are you asking that why in some matters it is the board which files the complaint, and in some matters it is the central government which files the complaint? Is that your question?
No. My question is why only IBBI is filing complaint, not central government?
No, IBBI is, so actually, the board is an independent regulator. So practically, a board is an independent regulator, but the board, is not different from the ministry, the MCA. So usually the authorized is the IBBI, and again, in case the matter concerns specifically any offense under the IBC, then the board will file the complaint. But in case the matter concerns the Companies Act or any other legislation which is not within the domain of the board, then the MCA will file the complaint. I believe this is what should be the consistent stand in filing of these applications. Right, let's proceed. So now there is just some explanation. So what offenses are triable by the special courts? So I think we have discussed most of it. And this is in the Companies Act, section 437, appeal and revision, and section 438. So these relates to the company's matter. And some of these cases decided by the special courts. So as you can see, one case is the case filed by the Insolvency and Bankruptcy Board versus Aniruddha Mukherjee. And this was criminal case in 2019 before the Special Court of Kolkata. The petition was filed by Aniruddha Mukherjee for bail was allowed with surety of rupees 20,000 to learned ACM Kolkata. However, the applicant was asked to be present whenever called and asked to submit their passports to the court within a week of the order. So these are some orders that case was filed, but there is an order for whatever reason. And then there is another case from Delhi, 2020 case in Dwarka, application filed by the board against the KMP of the CD for non-cooperation with the RP as per provisions contained in section 236, subsection 2. The complainant, that is the board, has powers to set the criminal law into motion through its authorized officer. After considering the documentary evidence placed on record, the court was satisfied of the offences prima facie committed, hence cognizance was taken, and now the trial must be continuing. Then we have another case, which is the board versus Sandeep Singh Madhok, 2019. Again, special court. So in Delhi, Dwarka has this special court designated for the criminal offences, IBC and company matters. So again, these are two interesting cases which are filed by the board against the KMP of CD. So in this case, CD was undergoing liquidation and KMP had refused to provide the details of the assets which would be for sale. So I'm not sure about the whether this case is continuing or it has been disposed of. But yes, these cases were filed. So these are good examples that the board is filing complaints and pursuing cases for the offenses under IBC. Then we have another case, current Channa case, and again KMP of the CD for non-cooperation with the RP. Then you have another case, Vinod Kumar, 2019 in Gurugram. And again, against the KMP of the CD for not disclosing of the details of the properties and transactions of the CD to the RP. Then we have another one case, which is matter of PMT machines versus the Deputy Director of Enforcement. So this order was passed in relation to mortgage of properties in favor of banks which are not purchased from proceeds of crime. Same were purchased and mortgaged with the banks prior to the crime period. And ED is not precluded to attach other private properties and all other assets of the accused. So there are a lot of cases where similar circumstances are felt. ED, so I think this is an old case and now we have sufficient guidance after the Bhushan Steel case. So some more cases, I believe these Bhuvan Infra projects, Special Court Bangalore, again against the KMP of CD for non-cooperation with RP. And accused also made false representations for purpose of committing fraud and refused to disclose the books and documents of the CD. Then we have Liberty House Group in Cuttack. So application was filed against the SRA for contravention of the terms of the resolution plan. Prima facie case was made out and cognizance was taken, but I don't think anything is happening now in this case. And Gurugram. So again, the same Liberty House. So they did file the case, but I'm not sure what happened in this case. Criminal matters, trials take a lot of time, and yes, we should, yeah. So report of the Company Law Committee 2019, the Government of India has already taken few steps to decriminalize certain offences under the Companies Act. Pursuant to the recommendations of the Offences Committee, the Companies Act was amended to change the nature of 16 non-compliances from criminal to civil in nature. Then instead of being under the jurisdiction of the special courts, adjudicating officers now adjudicate these 16 civil violations through the in-house adjudication framework. This is also interesting. So for company matters, some things are moving, and let us hope that for IBC also, we will see in very near future. Right, thank you. We'll see. So complaints received. So IBBI, so this is the last segment. The board has regulatory oversight over the service providers, the IPs, IPAs, and we have seen some of these sections 196 and 217 to 220. So I think we have covered most of this now. It is okay. So section 19, yes, our friend had already asked regarding section 19. So section 19 is not offense, but yes, the adjudicating authority can order direct such personal or other person to comply with the instructions of the resolution professional and to cooperate with him in collection of information and management of the CD. So, but this is only for the personnel of the CD to extend cooperation to the IRP. So this is immediately after the moratorium is imposed and the CIRP starts.
Sorry, sir, we can't see your screen.
Screen, is it visible now?
Yes, of course, it's visible.
Yes, sir.
Somehow I see only you, sir.
Okay.
Let me reconnect. Thank you.
Yeah, sometimes this, but anyway, I've shared all of these, so you will receive it. No worries.
Okay, thank you, sir.
Right. So so these are basically some of the provisions which may not be criminal in nature, but at least these are the reliefs which can be given to the RPs. So the code casts duties and obligations on the stakeholders. And as far as section 19 is concerned, the obligation is upon the CD and its officials to provide all support and cooperation to the IRP. And for that, the court, the NCLT can provide any order issue any order to the CD or any of its officials to comply with the insolvency order, with the insolvency proceedings and cooperate with the RP or IRP. Now, what happens when the CD does not cooperate or even does not allow the IP to enter into its premises? And the IRP have filed applications in several occasions seeking interventions of the AA, which passed appropriate orders. And one of this is the PNB versus the Jyoti Sponge Iron. And in this case, the RP sought necessary assistance and security to him to visit the factory premises of the CD to carry out the statutory duties and obligations peacefully. The AA ordered, keeping in view of the direct threatening by the CD, it is ordered that copy of this order may be served on the Director General of Police, West Bengal, SP, and in charge of this police station for making proper and effective assistance to the RP in valuation of the company. In discharge of his duty, any interference in the work of the RP, action shall be initiated against the CD, and it will be presumed that CD is not obeying the order of the court. It is expected that CD should fully cooperate with the RP. So some such orders have taken place. I think some.
Can I ask a question, Doctor?
Yeah. Yes, please tell me.
Now as far as the duties and obligations are concerned, in your previous slide, if you can go back to your the slide. So you have this 19 where the personnel of the corporator have to extend cooperation to the RP, and now that is well understood. Now, if there is a accounts of previous years which have been still unaudited, previous year to the CRP, that is, and let us say the directors of the corporator, we would the RP would typically want the directors to sign off on the accounts. The directors duly sign off on the accounts. Okay. And then as far as the final adoption is concerned, it goes to the AGM. the shareholders do not pass the accounts. Now, is that, I mean, as a shareholder, is he bound by the Section 19 to pass the accounts? And what is the recourse that RP has in this event?
Well, I believe that the rule consistent is that upon the starting of CIRP, the board of directors, they have no role, and the shareholders, I mean the meetings. So whatever resolutions are approved by the COC, it will be considered that there is a, I mean, so the only thing is that after the insolvency has commenced, I'm not sure how the shareholders meeting can take place.
So are you saying that then AGM is not required to be held after the CRP is been initiated?
I think this is what is consistent.
Sir, actually, what is happening, you are very much right, but what is happening, for some reason, IBVI has inserted a section, a clause in section 17, RP has to comply with all applicable. Interpretation has been made in such a way that even if it is not possible to do, RP is responsible for it. Example is AGM and getting accounts approved from the shareholder. Law is very settled on the issues. RP has to do what is possible. I can't be asked to do something impossible. And for past acts, I am not responsible. So this all what Mr. Nanavati is asking is arising from that particular provision of IBVI. Even now, for past offences and no past non-compliances, departments are writing to IPs, EPFO, ESIC, and everyone. Why you have not done a compliance? Why IP is supposed to do? Regulation 39, sub-regulation 7 is very clear. And as a matter of law, a person who is in charge at the time of commitment of offense is responsible. Why IP is responsible for this? Again, IBVI has completely misunderstood that anything which is not complied in past, it cannot be done now. How IIP can certify the past data? It is not possible for me. My duty under the IBC is to provide information, not to authenticate information or to create information. If something does not exist, I am not responsible for that. Regulation 39, sub-regulation 7 is there, but IBVI, I don't know for what reason they amended a section 17 and IRP has to comply with all applicable law. This is a statutory contract. Even in a statutory contract, section 56 of the Contract Act will apply that inability to perform. If something is not performable, how can I do it? But all authorities, even IBVI, they keep on asking why it has not been done. How can I do? First question is that nobody is answering that. As you rightly said, AGM.
Jain sir, if I may interrupt, there is another perspective also from which I am saying this. See, unless the accounts of the previous period are not adopted, I cannot initiate the accounts for the CR period.
That is the fact of the life. No one is willing to
now, if I have to prepare the accounts for the CR period, I necessarily need to get those
opening balances.
Opening balances के लिए.
So IBVI is Mr. Nanavati, you're right. IBVI is completely blank on this. Procedurally, how things work in the company and whether it is this something what they have asking can be done or not. It is impossible to act kind of situation.
Yeah. Okay. Thank you, gentlemen, for your interjections and observations. So yes, there are certain implementational challenges, but I'm sure that through the practice, some of you are managing these circumstances. So I would suggest, although I might have some response, but I will refrain from commenting on this matter. The better would be, the guidance provided by experts, and probably the practice which is adopted is that you just give it as it is. As you just mentioned that the companies into IRP, and this was the situation. So some sort of a declaration to this effect has to be provided, although it may not satisfy the regulatory compliances in some circumstances. But I would not have a, I would not be the appropriate person to comment on this matter, but I do agree that some of these implementational challenges have been faced. But I'm sure that the practitioners have some guidance on how to proceed on these matters.
Sir, there is no guidance. Only thing is that you speak to IBBI. IBBI will say go to NCLT. NCLT said how we can help you. So I'm telling you the practical side. This is what is happening. So we are going what you call 2 steps ahead and 3 steps backward. So this is funny. Of course, we enjoy it. How things are working as a implementer for IBC. We need all these legal and everything. But thing is that regulator has to be wise. Lawmaker has to be wise. They don't listen to people like you. I'm not sure how many situations you give and how much they have considered. But one has to consider the practical things. And whenever there is a policy making decision, you have to involve the people who actually implementing. We have not seen any of the committees of IBBI or the government where even a single person who has actually implemented 5 assignments, forget 5, 2 assignments have been appointed. It's all so-called expert having no practical knowledge at all, or they have been giving recommendation for XYZ reason, which are not otherwise possible.
No, but your IPAs are in all meetings.
I'm sorry, sir?
Your IPAs are in all meetings or all committees.
Sir, IPAs are another what you call you say of no use. There are 2 regulators,
Oh, no,
2 regulators, one of them is shadow of another. Let me become very
anyway,
honest with you.
so I think let's proceed further to the next topic. I do understand some of these issues. Yeah, no worries. I understand, but you are doing a very, a great job, and you are a backbone of the entire IBC ecosystem. And I'm sure that these genuine issues are being considered, and some sort of a guidance will be provided fairly soon. So there is another famous case, Hotel Godawan case, which happened a few years back. And in this, the IP sought protection for all acts done by him in good faith and to save him from the frivolous allegations made in a FIR. The adjudicatory authority observed if there is any complaint against the IP, then the board is competent to constitute a disciplinary committee and have the same investigated from investigating authority as per provision of the section 220 of the code. If after investigation the board finds that criminal case has been made out against the IRP, then the board has to file a complaint in respect of the offenses committed by him. So it is for this, with this object that protection to the action taken by IRP in good faith has been accorded by section 233 of the code. And section 233 provides this sort of an immunity to the IPs for any acts done in furtherance of their duty. So it's protection of action taken in good faith. And there is also a complete bar of trial of offences in the absence of filing of a complaint by the board, as is evident from perusal of section 236, clause 1, clause 2 of the code. Therefore, a complaint by Mr. Harendra Singh, a former director with the SHO, would not be maintainable and competent as the complaint is not lodged by the board. The jurisdiction would vest with the investigation officer only when a complaint is filed by the board. So there have been cases, IP has gone and the directors of the company or the CD, they are filing complaints, but this is not possible in these circumstances. So besides the direction of the adjudicatory authority, code provides for several offenses and penalties. And chapter 7, so we have already covered a few of them. Punishment in matters relating to the CIRP. And where the board has received few complaints alleging commission of offences, the board is required to file complaint before the special court in accordance with section 236. The board may also file a complaint suo motu based on material available on record. However, it may not be prudent for the board to forward every complaint it receives to the special court without due application of mind. Initiating criminal prosecution by way of a complaint entails mobilization of public resources such as money, time, human resource, including valuable judicial time. In view of the above, it is felt that the board may devise a policy relating to handling of complaints under section 236 of the code to ensure that false, frivolous, and malicious complaints are not filed in the special court, while no genuine complaint goes unprosecuted. Right. So I think this is the topic, and I believe we may have other cases as well and matter for discussion, but I rest my case here. I believe this is all what I wanted to discuss with you. And if you have any questions or observations, you are welcome. Although I really enjoyed this interactive session with all of you. Still, any further observations or questions, welcome.
Sir, that I have shared the Bombay High Court judgment.
Right.
Yeah, so I think the point which I was referring, so maybe next time whenever we have any session with you, we can discuss it.
No, I think it was clarified by Mr. Thukral that I believe it was regarding the constitution of the special court, which can only be at the level of session courts, not below it.
But this judgment says otherwise, sir.
Okay.
If you read the last para, if you see the last concluding para, it says, or it should be called ACMM or judicial magistrate, not session court.
No, actually,
Okay.
there is a division between the two type of offenses. If you see section 435(2), so there are offenses which are punishable with imprisonment of 2 years or more, and then there are offenses which are punishable less than 2 years. So the offenses which are more than 2 years are to be tried by sessions court, and which are less than 2 years are to be tried by the metropolitan magistrate or the judicial magistrate first class. So this judgment would also deal with the same issue.
Yeah,
Okay.
I agree. I agree, because we have read that in some cases punishment is still 6 months. In some cases punishment is around 1 year. So those cases will not go to the sessions court. Those cases will go to as per the jurisdiction of the as per the CRPC. So as per the CRPC, if jurisdiction will go to the metropolitan magistrate, then it will be that court only. So that CRPC jurisdiction rules will be must have been taken care of in this judgment.
Okay, I will read once again, sir.
Yeah, no, it is consistent. It's consistent jurisprudence.
It's consistent. Okay.
Yes, it is as per the punishment.
Otherwise, if you read 435, so it will be clear. 435 of Companies Act, that's a very, very simple wording, and no much of interpretation or intricacies involved.
Okay, so any further questions? So I think we are getting off a bit early, but yes. So now, we still have, if anyone wants, we can have some general discussion as well.
So, sir, coming back to one more query, section 69. If you see the language of section 69, so there are multiple offenses have been given. But are they interconnected or independent of each other, all of them?
No, they are all independent.
Because last it is coming as if all these acts have been done to get the execution or decree.
You are talking about 69.
Yeah, 69, sir.
69 is punishment for transactions defrauding creditors. Now it says if officer of the CD, so these are all, okay, A and B. So these are two different, usually these are two different wrongs.
So two different
A,
wrong. A and B is okay, but in A, all these offenses to make gift, transfer, or change or has to be in the execution of a decree, or they are independent. I can, if I make a gift or transfer or change, they're independent of what you call this decree or something. See, all these offenses should be connected with the property and they're
property,
independent.
yes, this is very clear. Has made or caused to be made any gift or transfer of or charge or caused. So it says, it is very clear. Has made or caused to be made any gift or transfer of or charge on or has caused or connived in the execution of a decree or order against. So there are several circumstances. It's not only in the decree, it is has made or caused to be made any gift or transfer of or charge on or has caused or connived in the execution of a decree or order against. So the main fact of the matter is relates to property of the CD. And B is order for payment of money obtained. So A is for the property and B is for the decree of payment of money.
So even in A, all these are independent offenses. Gift or transfer or
Yes.
charge or
Yes.
connivance in execution of a decree or order.
Yeah, because or is mentioned.
Or is mentioned there.
Yeah. And is not mentioned. Had it been and, then all of this must be satisfied.
Sir, going to section 70.
Okay.
There are multiple offenses which have been listed.
Hmm.
And if you see the what you call after F, one lakh or 1 crore, which the penalty has been given. So, and the second, and the proviso says there is no intention to. So, intention remains a very big issue.
Provided means the proviso. Proviso means that
proviso.
Exemption given to the affected person. So whoever is the accused person cannot be, the offense cannot be held to have been satisfied till the time the mens rea is not there. So this is a general rule of criminal liability, that the mens rea has to be established. So in case mens rea is not established, then the accused will not be provided this imprisonment which is mentioned in the para below F. So this punishment which is mentioned, 3 years to 5 years and fine 1 lakh to 1 crore, will not be imposed in case the mens rea is not established.
See, there's a practical problem which we face, as I mentioned earlier. It is neither the directors nor the KMP who is doing this. What they will say, I was not in charge. It was some employees, lower level employees like accountant, who is neither falling in the definition of accountant or any of these things. He was in charge and he doesn't provide, or rather he will leave the company at that moment. So it remains very, what you call a fragile position, because under this section, there is nothing against that employee. And usually they cite that I was not paid, that is why I left.
You are not concerned. You should not be concerned with the employee. The Companies Act provides the obligation upon the KMP. So KMP have to manage their employee, and company is responsible for the wrongs of the employee. So you may be dealing with the KMP, and it is the KMP's responsibility that all the employees are working properly, but for for some wrong committed by any individual, that individual will be liable, and because it is by the company will also be liable. So I don't understand why you should be concerned that it is not the KMP, it is some other person. I
So
mean, the question is,
mean to say,
you should not be concerned with that at all, because you just have to provide that information to the board, and the board will examine the circumstances and make the complaint. So it's not your responsibility. I mean, you just have to provide that. And yes, you are right. If you provide the sufficient case to the board may investigate, and the board may try to find and seek some more information from the CD and the KMP. And if they feel that there is sufficient reason, they may initiate the criminal proceedings, and then the trial judge will issue the notice to summon the witness and the other people. So that will be taken care of. So your role is just to prepare the, let's say, the
prepare and
MFSA
not,
case and send it to the board.
and not to get diverted to employees as done by the management.
Yeah, I mean, so I think that is consistent, so uh, I mean, employee will be working. So I will not be able to comment upon these micro issues. Some case might be some employees not working, but ultimately you have to manage how to work with them, and section 19 is there. In case any official of a company is not cooperating, and again, uh, so if it is a criminal proceeding, then you have to submit the material to the board. But if it is some other help or some other order is required, like section 19, then you can just seek the order from the NCLT, and I'm sure you should get the needful done.
Okay, thank you, sir.
Participants, do we have any other question from the faculty? If we don't have any questions, Risham sir, can we conclude this session?
Yes, thank you. You may conclude, and thank you for all of you for the patient hearing, and I hope the session was informative for all of you.
So on behalf of ICSR IIP, formally I would like to place vote of thanks for our today's faculty, Dr. Risham Garg, given his precious time to the participants and deliberations on the topic. So thank you, sir, for being with us for these 3 hours. Participants, we are having a break and we'll start the next session at 1:30 p.m. sharp. The Google form link for the questionnaire will be shared after the conclusion of the whole workshop with all the participants in the chat box. So we'll meet 1:30 sharp again. Thank you.
Thank you, Surbhi. Thank you, ICSI, and thank you all.
Thank you so much.
Thank you so much.
Thank you, sir.